Case 31. Buck versus American Airlines. We find ourselves in the U.S. Court of Appeals for the First Circuit. Facts. On November 4th, 2004, 15 individuals filed suit against several airlines and related entities in a Massachusetts state court. The plaintiffs alleged that the defendants had wrongfully retained fees and taxes collected at the time of their purchase of non-refundable tickets. This retention of funds was wrongful, the plaintiffs maintained, because they never used the tickets, and thus the fees and taxes, which did not become due until the commencement of air travel, should have been refunded. The defendants removed the case to the federal district court. The plaintiffs, now reduced to 9 in number, served an amended complaint that named 6 domestic and 7 international airlines as the culprits. The fees and taxes said to have been wrongfully withheld include passenger facility charges, customs fees, immigration fees, agricultural quarantine fees, security fees, and charges on behalf of foreign sovereigns. The amended complaint named as additional defendants 2 trade associations, Airlines Reporting Corp. And Air Transport Association of America, which now has become Airlines for America, alleging that they had been complicit in allowing the airlines wrongfully to retain the fees. Most of the defendants moved to dismiss on the ground, inter alia, among other things, that all the claims were preempted by Section 105 of the Airline Deregulation Act. The district court granted the motion to dismiss. The court, acting sua sponte on its own behalf, extended its ruling to cover those defendants that had not joined in the original motion. This timely appeal followed. So what's the issue? Whether to let stand the plaintiff's multitudinous statements of claim, including counts for declaratory judgment, rescission, breach of contract, unjust enrichment, breach of a covenant of good faith and fair dealing, breach of fiduciary duty, and civil conspiracy. Whether, in addition, the plaintiffs were entitled to an implied right of action arising under a federal regulation. So what was the holding? The court held that the plaintiffs were fruitlessly endeavoring to fly in unfriendly skies, and consequently affirmed the order of dismissal. Here's the reasoning why. First, let's explain the requirements of 14 CFR 253.4 and 253.7. The court began its analysis with the plaintiff's lone federal law claim, the claim of an implied right of action. These provisions govern the disclosure of terms in contracts for air travel. Among other things, they prevent airlines from claiming the benefit of contract terms not incorporated by reference in a specified manner. These regulations go on to restrict the authority of airlines to impose monetary penalties on passengers without clear notice. Meanwhile, 14 CFR 253.7 provides that airlines must give conspicuous notice of refund restrictions. A carrier may not impose any terms restricting refunds of the ticket price, imposing monetary penalties on passengers, or raising the ticket price consistent with Section 399.88 of this chapter, unless the passenger receives conspicuous written notice of the salient features of those terms on or with the ticket. Let's discuss a private right of action. Regulations alone cannot create private rights of action. The source of the right must be a statute. The regulations upon which the plaintiffs relied in the Buck case were promulgated pursuant to 49 U.S. Code 41707, a statute that has its roots in the CAB, the Civil Aeronautics Board, Sunset Act. The CAB Sunset Act embodies a series of amendments to the ADA, which 6 years earlier had significantly revamped the Federal Aviation Act. The court had rejected an entreaty to imply a private cause of action pursuant to other regulations implementing the ADA. In the process, quote, "We made clear that for the purpose of implying private rights of action, the Federal Aviation Act and hence the ADA is barren soil. To cinch matters, the court says, every court faced with the question of whether a consumer protection provision of the ADA allows the implication of a private right of action against an airline has answered the question in the negative. The court saw no justification for creating a circuit split and held that the consumer protection provisions of the ADA do not permit the imputation of a private right of action against an airline, and that therefore the plaintiffs do not have an implied right of action under 14 CFR 253.4 or 253.7. Let's discuss an implied right of action a little bit more. It's a term used in U.S. statutory and constitutional law for circumstances when a court will determine that a law that creates rights also allows private parties to bring a lawsuit, even though no such remedy is explicitly provided for in the law. Implied causes of action arising under the Constitution of the U.S. are treated differently from those based on statutes.